All right, next item on the agenda is appearance by members of the public.
Dr. Carla Campbell-Jackson from the NAACP, and she has joined us by phone. So Dr. Campbell-Jackson, you have the floor.
And thank you kindly, Ms. Rodriguez. I certainly hope I'm audible.
Yes, you are. We can hear you well.
Excellent, excellent. As the world's oldest, largest, and most respected civil rights organization, the NAACP supports and endorses the tenets associated with House Bill 3653. Prior to the recent onslaught of police brutality against people of color, the Illinois NAACP was on the forefront of policing issues, as we have proudly affirmed the 10 shared principles which have been adopted from across our state. Every city from Chicago to East St. Louis has embraced the shared 10 principles. At the end of the day, we want the board to know that we value every life and that we want all people to be treated with dignity and respect. That includes if they're stopped for common traffic violations or for any other issues. Additionally, we endorse the 4 pillars of procedural justice, which are fairness, transparency, the right to having a voice, and impartiality. Please know that the NAACP respects the work enforcement agencies when their acts are conducted decently and in order without regard to race or socioeconomic class. Many members of the NAACP have family members who are diligently serving as members of the law enforcement. I have a cousin who's a captain in the St. Louis area, and I also have a cousin who works in New Orleans as a member of the police team down there. However, we know that racially motivated policing is discriminatory, deplorable, and simply intolerable. The amendment that was brought forth a month and a half ago does not support our aim for justice and equality. As such, the Bloomington-Normal branch of the NAACP is recommending that the McLean County Board cease and desist with sharing any misinformation about House Bill 3653. Instead, we must work together to support a bill that is good for our police officers as well as for our citizens. This collaborative effort will help to replace mistrust with mutual trust. Mutual trust is critically important as we all want to work toward a more perfect union. Please feel free to contact the NAACP if interested in further collaborative efforts. And with that, Ms. Camille, I thank you for the opportunity to share.
Thank you, ma'am. Thank you so much. I will now ask Ms. Willie Halbert to come to the podium. I'm going to move aside.
Just like to say good evening to everyone. Greetings to the McLean County Justice Committee. My name is Willie Holton Halbert, and I am a 40-year resident of Bloomington-Normal and retiree from the Illinois Department of Corrections, where I served as a counselor, a casework supervisor, and assistant superintendent for over 20 years of service. I'm currently running for the Bloomington City Council Ward 3, and one of my main platforms is equity for all. It should be noted, I have a genuine respect for our criminal justice system and our police department. Officers put their lives on the line every day as they protect and serve. My husband, Charles Halbert, served on the Fire and Police Commission for over 12 years, and part of that time was the chairperson. So my support is unquestioned regarding public safety. At the same time, the House Bill 3653 that recently passed only strengthens our criminal justice system and police and provides equity among all people. The tragedies that we witnessed this past summer uncovered major flaws with our system that would allow such inhumane treatment to a person being arrested, and especially as our history has dictated that horror of treatment that has been documented of people of color. It is about justice for all. People from every walk of life gathered right here at our Law and Justice Center this past summer. Black, white, Hispanic, young, old, parents, children, friends, over 1,000 plus, to share and demand justice of such horrific injustice we all observe on public TV and reliving through the trial of the officer today. This bill helps to ensure these types of injustice does not continue, but all are held accountable. House Bill 3653, Criminal Justice and Police Reform, was authored by the Illinois Legislative Black Caucus and was approved by the Illinois General Assembly and signed into law by our governor. Unfortunately, there has been so much misinformation regarding this bill that implied that it lessened the authority of our criminal justice system or police departments, spreading the misinformation that the House Bill 3653 ends qualified immunity for law enforcement, all which is not true. The significant changes do in fact deal with police training policies, police accountability, transparency in law enforcement, and the rights of detainees and prisoners, as quoted by Senator Sims, who sponsored the bill. Among the changes the bill would bring are the elimination of monetary bail, a requirement that all police officers wear body cameras by 2025, a ban on all police chokeholds, new guidelines for decertification of police officers, and an end to suspended license for failure to pay, among several other changes. In addition to the increase for officers that have known information but afraid to come forward due to retaliation, and add to the right for detainees to make phone calls and access their personal contacts before police questioning. I won't go into all the details because I'm going to leave copies of this report for you to review. In conclusion, the changes in the bill are to assist and to help our police department's criminal justice system to be more effective and humane in serving all people with respect while still providing and performing their jobs. So the killings, like what happened with George Floyd or Breonna Taylor, would not happen again. To treat every human being with respect while yet protecting our community and helping to keep our officers safe, it has everything to do with basic human rights and equity among all people, regardless of one's economic status. I recommend that the Justice Committee, prior to filing resolutions and pass judgment on a bill, to do due diligence and ensure proper information is being distributed. Respectfully submitted, Willie, Holton, Halbert, and I do have copies that you can provide to all of you.
I will be happy to do that.
Thank you.
Thank you. Chairman Erickson, we have one more speaker. His name is Zachary Gittrich, and we are going to escort him into the conference room at this time.
Thank you, most honorable and esteemed county board members. I am here on behalf of the Solidarity Research Working Group of the Bloomington-Normal Socialists. I want to start by thanking the honorable chairperson for bringing the issue of qualified immunity up. I think this is a very important discussion to have. HB 3653 does not get rid of qualified immunity, unfortunately. However, there is a bill in the General Assembly, HB 1727, which would abolish qualified immunity for officers. I wanted to address some spurious comments Mr. Spanos made regarding my comments last month. I had characterized qualified immunity as protecting unreasonable behavior, and Mr. Spanos said that was incorrect. Now, I'm no county country lawyer, so when I made these statements last month, I was actually quoting distinguished law professors Joanna Schwartz and Seth Stoughton. Let's be clear, Derek Chauvin, Alexander Kung, Thomas Lang, Tu Tao, the officers involved in George Floyd's death will most likely receive qualified immunity despite international condemnation, including from law enforcement and many conservatives. Jonathan Mattingly, Brett Hankinson, Miles Cosgrove, the officers who murdered Breonna Taylor while she was sleeping in her bed, will get qualified immunity. Nathan Woodyard, Jason Rosenblatt, and Randy Rodema, the officers that murdered Elijah McLean, will also likely receive qualified immunity. Mr. Spanos, if you believe these cases are reasonable mistakes, then your definition is most unreasonable. Under qualified immunity, government workers can only be held accountable for violating someone's rights if a court has previously ruled that it was clearly established these precise actions were unconstitutional. If no such decision exists, the official is immune, even if the official intentionally, maliciously, or unreasonably violated the law or constitution. The primary consideration in qualified immunity analysis is whether there is an earlier court case specifically stating that the particular actions of an official are unconstitutional. For example, the U.S. Court of Appeals recently held that a prison guard who pepper sprayed an inmate in his locked cell for no reason did not violate a clearly established right because a similar cited case involving a law enforcement official who tased an inmate for no reason rather than pepper spraying them for no reason. A police officer shot a 10-year-old child while trying to shoot a non-threatening family dog. The Court of Appeals held that the officer was entitled to qualified immunity because no earlier case held it was unconstitutional for a police officer to recklessly fire his gun into a group of children without justification. Qualified immunity applies even when officials intentionally or recklessly violate the law. Again, the U.S. Court of Appeals held that police accused of stealing $225,000 while executing a search warrant were entitled to qualified immunity because the court had never addressed whether the theft of property covered by the terms of a search warrant violates the Fourth Amendment. It did not matter that virtually every human society teaches that theft generally is wrong. Again, Mr. Spanos, if this is your definition of reasonable, I don't even want to know what you consider unreasonable. Even if qualified immunity for officers were abolished, they still wouldn't pay a dime because they are indemnified by the county for all actions, and the county has a duty to defend said officers if they are sued. This is all in the union contracts, and I encourage you all to look it up. Beyond qualified immunity, I do want to address what has been going on in the jail. Until the last week or two, all inmates were kept under solitary confinement for months. This is the sheriff's primary COVID mitigation strategy. The United Nations rules on imprisonment, called the Mandela Rules, state any solitary confinement longer than 15 days is cruel and unusual. McLean County inmates were in solitary for over 120 days. This is despite the fact inmates were eligible for COVID vaccines as early as January, according to the State Health Department, and in direct contradiction from the sheriff's previous statements to this board. I've spoken to other sheriffs who were aghast that our most perfidious sheriff would implement such a harsh policy for this long. In early November, the sheriff had all inmate windows covered up, preventing them from seeing out, and I can only assume preventing very little light from entering. I would be interested to know if there were any vitamin D deficiencies this past winter, which would have increased the mental trauma they experienced. Besides multiple requests to county board members, I still can't get an answer on how much this cost or how it was paid for. I'm not exactly sure why this is so difficult for some of y'all to ask this question. Thank you and have a good day.
Thank you. Chairman Erickson, that concludes our public speakers for this evening. Thank you.